Ladies and gentlemen, my name is Agnieszka Gryszczyńska and I'm a professor at the Faculty of Law and Administration of Cardinal Stefan Wyszyński University in Warsaw. Moreover, I'm a prosecutor in the National Prosecutor's Office in Poland. I wish to warmly welcome you on the second scientific seminar titled The Definition and Scope of Cybercrime. Conceptualization and categorization are indispensable parts of any research on cybercrime. This seminar is dedicated to presenting the definitions and typologies developed by the recent literature, as well as the scope of criminalization provided by certain international legal instruments. New trends of cybercrime will be also discussed, in particular, the criminal offenses committed in the context of social media and money laundering. Additionally, selected issues of investigation and prosecution of cybercrimes will be presented, namely the activities of law enforcement agencies for countering cybercrime and the issues of investigation in Hungarian cybercrime cases. We have 6 members of the cybercrime team presenting their papers at today's seminar. According to the agenda of today's seminar, I will start with my speech titled Scope of Criminalization in the Budapest Convention and the Draft New United Nations Convention. So I will just share my screen with my presentation. Okay, I hope you can see my screen. Okay, if it's visible. So, cybercrime has transitioned previously geographically located crimes as fraud, theft, to a space without borders. By its nature, cybercrime is characterized by global reach, anonymity, and is of asymmetric effect. This makes it possible for a criminal with a single action to bring about the effects observed in many places at the same time. For example, infecting many victims with malware. Victims of such an act will report a crime to many different law enforcement units, for example, different police stations in different countries. What's more, actions in cyberspace usually have a cross-border nature. Their negative effects are observed in many countries. The perpetrators are also use infrastructure from many providers around the world. So an example is a case involving Korean military hacking units known by multiple names in cybersecurity community, including Lazarus Group and Advanced Persistent Threat 38. According to the indictment published on the Justice.gov website, the perpetrators launched attack on numerous financial institutions worldwide. Around October 2016, the hackers gained unauthorized access also to the Polish Financial Supervision Authority computer network and turned its website into a watering hole. The same group is responsible for WannaCry, ransomware attack, which was estimated to have affected more than 200,000 computers across 150 countries, which total damages ranging from hundreds of millions to billions of dollars. Since the specific features of cybercrime include its cross-border nature, international cooperation instruments in cybercrime are necessary to identify and detain perpetrators and recover financial criminal assets. Both in domestic law and in regulation of an international nature, a significant problem that also affects the prosecution of perpetrators is the scope of criminalization and the definition of cybercrime itself. At the beginning, a disclaimer should be made that also Polish law has no legal definition of cybercrime, as well as no catalogue of actions considered as cybercrimes. There is also no single definition of cybercrime in the European Union and international law. The term is referred to a wide range of different criminal activities directed against the confidentiality, integrity, and availability of information systems, networks, and data, as well as their misuse. It can include crimes committed to violate goods traditionally protected by criminal law, including in particular crimes against property, fraud, theft, burglary, crimes against liberty, for example, persistent harassment, identity theft, crimes against the credibility of documents, for example, material falsification of a document, content-related crimes as crimes against as so-called crimes against sexual freedom and morality, including dissemination of child sexual abuse material on the internet, crimes against peace and humanity, such as incitement to racial hate, and crimes specific only to data networks and information system. For example, attacks on data availability, including, for example, distributed denial of service, creation and distribution of malware, crypto hijacking. That's why we can divide cybercrimes into many categories, depending on the criteria you use. The most common is the division on cyber-dependent crime and cyber-enabled crimes. Moving on to discuss the Budapest Convention, the Convention on Cybercrime, also known as Budapest Convention or Cybercrime on Budapest Convention, is the first international treaty seeking to address internet and computer crime, cybercrime, by harmonizing national law, improving investigative techniques, and increasing cooperation among nations. The convention aims principally at harmonizing the domestic criminal substantive law elements of offenses and connected provisions in the area of cybercrime, providing for domestic criminal procedural law powers necessary for the investigation and prosecution of such offenses, as well as other offenses committed by means of a computer system or evidence in relation to which is the electronic form, and setting up a fast and effective regime of international cooperation. The Convention accordingly contains 4 chapters: use of terms, measures to be taken at domestic level, substantive law and procedural law, international cooperation, and final clauses. So if we check the range of Budapest Convention, this convention is international conventions. The last country that joined the convention was Brazil. And it's really not only Europe to be in that convention. And so according to the Budapest Convention, several activities were identified to be cybercrime offenses. Section 1 of Chapter 2, Substantive Law Issues, covers both criminalization provisions and other connected provisions in the area of computer or computer-related crime. It first defines 9 offenses grouped in 4 different categories when deals with uncial liability and sanctions. The following offenses are defined by the convention: illegal access, illegal interception, data interference, system interference, misuse of devices, computer-related forgery, computer-related fraud, offenses related to child pornography, and offenses related to copyright and neighborhood rights. Moreover, on March 2006, the additional protocol to the convention, to the convention on cybercrime came into force. So here we have another so-called content-related offenses related to criminalization of the dissemination of racist and xenophobic material through computer systems, as well as threats and insults motivated by racism and xenophobia. In a moment, I will try to compare the scope of the substantive criminal law provisions between the Budapest Convention and a draft new United Nations Convention. But first I would like to say a few words about the draft convention. So through the resolution of the General Assembly dedicated to establish an open-ended ad hoc intergovernmental committee of experts, representative of all regions, to elaborate a comprehensive international convention on countering the use of information and communication technologies for criminal purposes, taking into consideration existing international instruments and efforts at the national, regional, and international levels on combating the use of information and communication technologies for criminal purposes, in particular the work and outcomes of the open-ended intergovernmental expert group to conduct a comprehensive study on cybercrime. So it was the motivation. There have already been 5 sessions of ad hoc committee. Ahead of us is another one, the 6th session scheduled for August this year. All the information is provided on the United Nations website. As we are talking about the convention, one of the most discussed problems is the problems of substantive scope, the scope of criminalization. So here you can see some summary I've made for you from the consolidated negotiation document. So it's not the final version of the draft convention. It is still only the negotiation document. And as you can see here, the scope of the convention can be much broader than the Budapest Convention on Cybercrime. So we have here clusters that include similar articles. In the first cluster, we have those crimes that are well known from Budapest Convention on Cybercrime, and those that are cyber-dependent crimes. But we have also here, for example, in cluster 8, something that is very controversial, like extremist-related offenses, as incitement to subversive or armed activities. We have also cluster 9 that includes arms trafficking, that are not cyber dependent crime, and it's something new. But for example, during the negotiations, different countries provided their own vision of new instrument of law. For example, the Russian Federation's proposal is very broad. It was submitted during the first session. Russia provided draft version of the whole convention. So you can find this version on the website of the United Nations. This proposal covers such crimes as disinformation. So Russia's positions tends to support or align with that of China and North Korea. So there are different, let's say, views of the criminalization in the new convention and the scope of the new convention. So I would like to show you very briefly, because my time is limited, what is in the Budapest Convention, because the Budapest Convention is still one of the best regulations regarding fighting cybercrime. And what is in ad hoc committee consolidated negotiating document. So we have very similar regulation of illegal access in both instruments. We have also illegal interception in both instruments. We have data interference, very similarly regulated. As you can see here, we have in brackets computer data, electronic digital information. It means that there is no consensus on the terminology. So the terminology is still discussed. Of course, it's only a draft, and the terminology should be, let's say, maybe on the next session, there will be a decision what terminology would be in the new instrument. There is also system interference, very, very, let's say, comprehensive regulation on misuse of devices. Device is also a computer program. So the definition is very broad, not only in the Budapest Convention, but also in the draft consolidated negotiating document. And here we have some, let's say, big changes, maybe. At the beginning, many countries, especially the European Union countries, shows that the convention should cover only cyber-dependent crimes. And those crimes that are included in the Budapest Convention, here the computer-related offenses from Budapest Conventions are also provided, but there is also computer-related theft and illicit use of electronic payment instruments. Many countries show that, let's say, this regulation is not necessary because those actions are covered by computer-related fraud or forgery. We have big changes also here. So offenses related to child pornography. In the draft the new convention, the new terminology is supposed to be used. So not child pornography, but child sexual abuse or exploitation material is the proper terminology, as a child never take part in this action consensually. So here we have more articles on that matter. So we have offenses related to online child sexual abuse and exploitation material, facilitation of child sexual abuse or exploitation material through a computer system, grooming, cyber stalking, involvement of minors in the commission of illegal acts, encouragement of the coercion of suicide, sexual extortion, and non-consensual dissemination of intimate images. Some of those crimes are related not only to children, but also to adults, like, for example, dissemination of intimate images. Moreover, we have some regulation that is controversial still, but we have some new proposals that are acceptable for many countries, like, for example, money laundering. A lot of countries see the added value of including in the new instrument money laundering regulation. So maybe this Article 33 now from the Cluster 10 will be included in the final draft version of the convention. So concluding, cybercrime is one of the most dynamic form of crimes. The development of cybercrime leads to the revision of current legal regulation, the development of instruments of international cooperation in cybercrime cases, or the identification of new areas of criminological research. Changes in the threat landscape must be, of course, followed by changes in substantive and procedural law. Today's banks robbers use keyboards rather than guns and steal digital wallets of cryptocurrency instead of sacks of cash. By operating in cyberspace, they do not have to devise a plan for spectacular bank escape from law enforcement. Thanks to the abuse of anonymity provided by a service available online, they remain unpunished. Cyber attack attributable to state actors show that cyberspace is also an area for cyber operation or cyber warfare. It is increasingly difficult to demarcate what is a cybercrime and what is not. The problem is reflected in the work on the new United Nations Convention on Cybercrime, where the scope of criminalization is still under the discussion. The significant broadening of the scope of substantive laws in the draft convention, on the one hand, reflects the development of ICT applications for committing crimes. On the other hand, it may also indicate that some countries seeking a significant extension of the scope of criminalization thus want to use the convention to achieve other goals, including political goals related to supremacy in cyberspace. Unfortunately, the involvement of some countries in cyber operation and their support of cybercrime groups brings into question the effectiveness of international cooperation instruments in cybercrime cases, which are necessary due to their cross-border nature. So I thank you kindly for attention. And I will just stop providing my screen. I don't know if something, okay. So if there are any questions, please don't hesitate. There is also a chat section on the platform. If there are no questions, I would like to invite for the next speech Professor Ferenc Santa from the Institute of Criminal Law and Criminology of the University of Miskolc to present a paper titled Definitions and Categorization of Cybercrime, Cybercrimes in the Hungarian and International Literature. Professor, the floor is yours. You can provide your screen because you are presenter.
Yes, thank you, Professor. My question is, do you see the PPT?
Yes, we can see.
Yes, thank you very much. The topic of my presentation, as the professor mentioned, the definition and categorization of cybercrimes in the Hungarian and international literature. As Professor Agnes
Sorry, could
mentioned,
you please start the slideshow, because we see also some other information. Maybe if you start slideshow, it would be, do not close this. It is only this. Okay, now there is only a black screen.
A diavetítésre, Feri.
No, you just joined the conference. You don't have to click there. It is only the question of clicking the PPT, so your presentation, showing your presentation. No, not from this.
Feri, a mikrofon melletti kis karika.
oh no, sorry. No.
Lehet, hogy meg kell nyitnod a PPT-t, mert eltűnt a képernyőről.
Eltűnt, igen, próbálom egy pillanat.
Excuse me.
Yes.
Now we can see also the black only screen from your computer. We see that you are showing your screen, but okay, maybe one more time. Maybe try to show all the screen and just turn on the PPT slideshow.
Do you see it?
Yes, now we can see your presentation.
Okay.
But we also see all the slides here.
A diavetítésre kellene.
Oh, now we can see the second slide.
Yeah.
So you will click like this.
Okay.
Okay. If you cannot start slideshow, it can be like this. It's visible, so we can see them.
Okay. Thank you very much. So the topic of my presentation is the definition and categorization of cyber crimes in the Hungarian and international literature. And as Professor mentioned, the first step in any scientific research is to define the subject of the research. So for us, as members of the cybercrime research team, it is fundamental to answer the question of what we understand by the term cybercrimes. The term is nowadays widely used both in international and domestic literature, as well as in several international legal sources. My task is to review and analyze the international academic literature on the definition and categorization of cybercrimes. I note that this time I focus the international academic literature, but my first question is, why is it necessary to deal with the problem of the definition and the categorization? A clear and well-formed definition and classification of cybercrimes is essential, is fundamental for several reasons. A clear and well-formed definition allows more precise measurement of cybercrimes, and if we have more accurate data, the legal and non-legal responses to cybercriminality can be developed more effectively. A clear definition can help harmonize the cybercrime legislation in different countries, because now there are significant differences between European countries as to which illegal or deviant conducts committed in the cyberspace are considered criminal offenses. And if the domestic regulations of cybercrimes are based on the same principles and the statutory definitions of the individual crimes are the same or at least similar, the international criminal cooperation and generally the international efforts to tackle cybercrimes would become much more effective. However, to establish the clear definition and classification of cybercrimes is not an easy task, because the behaviors, the conducts covered by this concept are extremely diverse, and cybercriminality is constantly evolving and rapidly expanding. The definition of cybercrimes, first of all, I have to emphasize that I will use the term cybercrimes in this presentation and during the research, but I note there are a number of phrases to describe the phenomenon, and according to an excellent statement of the literature, problems in defining cybercrime begin with the terminology itself. The number of the terminologies is almost endless. Cyberspace crime, computer-related crime, electronic crime, e-crime, technology-enabled crime, high-tech crime, digital crime, internet crime, and so on. Until the 2000s, the most popular term was computer crime or crime by computer in the international literature, but nowadays the term cybercrimes is the most accepted and most commonly used. Of course, libraries could be filled with literature on the definition of cybercrimes or try to outline the system. You can see the slide. Basically, there are three basic types of definition of cybercrimes. The first is the so-called single definitions of cybercrimes. The second definitions refer to categorizations. And the third, the so-called taxonomies of cybercrimes. Let's see first of all the single definitions of cybercrimes. A single definition means that its author attempts to describe the phenomenon in a single longer or shorter sentence. Let's see some examples. According to Wall, a cybercrime when the occurrence of a harmful behavior that is somehow related to a computer. According to Gordon and Ford, cybercrime is any crime that is facilitated or committed using a computer, network, or hardware device. And according to a Hungarian author, Imre Kunos, cybercrimes are a set of crimes where information technology tools and systems are used as a means of committing crimes. It cannot be denied that these definitions are correct, but I think these definitions are too narrow, lack utility, and unable to provide a comprehensive picture of cybercrimes. Therefore, definitions refer to categorizations of cybercrimes are much more popular. Yes, let me see. The definitions refer to categorizations. A characteristic feature of these definitions is that the term is used as a working concept, an umbrella term, with 2 or 3 main categories. The 2-category classifications can be referred as dichotomies of cybercrimes, and the 3-category division is the trichotomies of cybercrimes. Let's see, first of all, the dichotomies of cybercrimes, the so-called 2-category classifications. You can see some authors, Klau, Grabowski, or Brenner. As I mentioned in my first presentation, the system that distinguishes between cyber-enabled and cyber-dependent crime, which I mentioned by the Professor Agneska, is the most widely used and adopted by international and Hungarian researchers. Cyber-enabled crimes are the so-called cyber crimes in a broad sense. These are traditional crimes or real-world crimes which have migrated into cyberspace. In these cases, the information system is the instrument used to commit the offense. You can see some examples of cyber-enabled crimes, for example, money laundering, drug trafficking, harassment, and child pornography. The other category is cyber-dependent crimes, which are the so-called cyber crimes in a narrow sense. These are criminal offenses that arose with the advent of technology and cannot exist outside of the digital world. They can only be committed using information system, and you can see some examples of these cyber-dependent crimes, for example, hacking, ransomware attacks, and phishing. And I note that there are further examples of this dual division, these 2-category classifications, because some authors in the academic literature making a distinction based on the motive of the crime, the motive of the perpetrator. So there are interpersonal cyber crimes when the motive is personal in nature, these crimes against person, and the property cyber crimes when the motive is financial gain. And the second category of definitions referred to categorization is the trichotomies of cyber crimes, the so-called 3-category classifications. The first type of this triple division is a definition which extends the above mentioned and widely used 2-category classification by a third category. So in this system, the first category is cyber-dependent crimes, or true cyber crimes, where the computer is the target and the crime could not happen without a computer, for example, hacking. The second category is cyber-enabled crimes or hybrid crimes, where the computer plays a significant role, but the crime could still be committed without the involvement of the computer, the typical crime, for example, fraud. And the third new category in the system is cyber-assisted crimes, or the use of computers in traditional crime, where the computer's involvement is incidental to a real-world crime and simply increases the opportunity for traditional crimes, for example, criminal communications. It cannot be denied that there are differences between in this system, the second and the third categories, but I'm not sure that there is a need for a separate third category in this system. The second type of the triple division is a definition which proposes a new 3-factor classification of cybercrime based on the role of technology. One of the most famous is the division of Wohl, who distinguishes between crimes against the machine, also known as computer integrity crimes, for example, hacking, cracking, or DOS attacks. The second category is crimes using the machine, also known as computer-assisted crimes, for example, piracy, robberies, and scams. And the third category is crimes in the machine, also known as computer content crimes, for example, online hate, harassment, or child pornography. And another and very similar example of this categorization is the definition of the European Commission, which uses the following terminology. The first category offense is unique to computers and information system, for example, attacks against information systems. The second is simply traditional offenses, for example, fraud, forgery, or identity theft. And the third is the so-called content-related offenses, for example, incitement to racial hatred. Finally, I mention a fourth, very interesting classification proposed by Sar, Lau, and Chang. They use also a three-factor spectrum system where the type 1 cyber crimes refer to crimes that are technical in nature, for example, hacking. The type 2 cybercrimes refer to crimes that involve human contact, for example, cyberbullying. And the type 3 cybercrimes refer to crimes that are committed by artificial intelligence, robots, or self-learning technology. My position is that the three category classifications seems more useful than the dichotomies of cybercrimes because they provide a more clear picture of the many different criminal conduct and take into account the evolution of technology and new tendencies of cybercriminality. And the third type of definition or definitions of cybercrime is the so-called taxonomies of cybercrime. The first question, what is taxonomy? Taxonomy is the process of naming and classifying cybercrimes into groups within a larger system according to their similarities and differences. It means a complex and, in many cases, complicated definition which attempts to comprehensively classify cybercrimes. Taxonomies of cybercrimes were developed both by international legal instruments and representatives of academic literature. An example of the first is the classification system of the Budapest Convention and its additional protocol, which was mentioned by Professor Agneska, which contains 14 different cybercrimes in 5 categories. Example of the second is the systematization of Wall, who proposed a system based on the distinction between person target and computer target crimes instead of the offense-based framework which used by the Budapest Convention, for example. The 4-category taxonomy of Wall is the following. The first category, titled cyber trespass, it is defined as the crossing of virtual ownership boundaries, for example, attempting to gain access to systems, networks, or data. The typical crime is hacking. The second group, titled cyber deception or theft, it is defined as the use of the ICT to either steal information or valuable items. This is typically achieved by cyber trespass, and the typical crimes hacking, piracy, and spam. The third group, titled cyber pornography and obscenity, it is defined as the use of the ICT to access sexually explicit and illegal sexual content. The typical offenses: pornography, child sexual abuse material, child sexual exploitation, sex trade, and sex trafficking. And finally, the fourth category, titled cyber violence. It is defined as causing harm in both virtual and real life environments. The typical offenses: online harassment, bullying, terrorism, politically motivated hacking, or organized crime. And there are taxonomies of cyber crimes which are more developed, which try to provide an exhaustive list of offenses in each category and take into account the latest developments in ICT and the latest forms of cybercriminality. Let's see an example. it is the taxonomy of co-authors, Phillips, Davidson, Farr, Burkhardt, Kanepel, and Eichen. They create 6 categories of cyber crimes, as you can see in the slide. The first, crimes against the machine. The second, crimes using the machine. The next, crimes in the machine. The fourth, cyber assisted crimes. The fifth is a special cross-category A, and the sixth is the also special cross-category B. And let's see the first group, titled Crimes Against the Machine, which means attacks against data and systems. And there are 2 subcategories in this system. The first, crimes against individuals and organizations. This group contains illegal access, illegal data acquisition, illegal interception, data and system interference, misuse of devices, extortion, ransomware, and haste. And the second subcategory in this category, crimes against states and nations. And the relevant crimes is political interference, cyber warfare, and espionage. The second group, titled Crimes Using the Machine, which means attacks against property and theft. The relevant crimes, computer-related forgery and fraud, copyright infringements, trademark-related offenses, digital piracy, spam, identity theft, phishing, and cyber fraud. The third group, titled Crimes in the Machine, which means violence type crimes. And there are 4 subcategories in this group. The first, interpersonal violence, which means harassment, cyberbullying, trolling, coercion, and extortion. The second subcategory, sexual violence, contains pornographic material, child sexual abuse material or extortion, grooming, stalking, image-based abuse, sextortion, sexting, sex trade, sex trafficking, and sex tourism. The third subcategory, violence against groups, contains hate speech, religious offenses, xenophobia, terrorism, and radicalization. And the fourth subcategory, violence in general, which means inciting violence, preparatory style offense, preparatory style offense. And fourth group, titled cyber assistant crimes, which means incidental technology use, contain illegal gambling and gaming, laundering and money moving, drug trade, and criminal communications. The fifth group, titled cross category A, which contains some forms of organized crime, deep web markets and illegal virtual marketplaces, and cybercrime as a service. And finally, the sixth group, titled cross-category B, which means information and behavioral manipulation. And there are 2 subcategories in this group. The first, using advanced technology, contains crimes committed by artificial intelligence, machine learning, algorithmic profiling, deepfakes, bots and botnets. And the second subcategory, using false information, which contains the so-called cyber troops, fake news, misinformation, and disinformation. And finally, my summary, my statements, or the first consequence of my research, that there is no universally accepted definition of cyber crimes. This fact had resulted in various definitions being put forth by academics and international organizations. I mentioned the single definitions. Single definitions of cybercrimes are, as I mentioned, often restrictive in nature and provide limited information on the characteristics of the crimes. Therefore, it would appear that the more popularly used definitions of cybercrimes are those that refer to broader categorization of cybercrime, namely the typologies and taxonomies. The two-factor approach, which using the terms cyber-dependent and cyber-enabled crimes, is dominant in the academic literature. This may be due to the fact that this definition makes a simple but clear distinction between types of cybercrimes. I agree with the opinion that the three category classifications of cybercrimes, which are based on the role of technology, are much more progressive because these reflect the likely future of cybercriminality, namely, most crime in the future will be facilitated by some form of technology, and the role of complex technologies in the commission of crimes will increase. However, in my view, the most advanced and most progressive definitions of cybercrimes are the taxonomies, namely the definitions that attempt to classify and categorize the relevant offenses and provide the most comprehensive list of the offenses. So a further task of my research could be to formulate a definition based on a taxonomy of cybercrimes that is compatible with international and national legislations, takes into account the new tendencies of cybercriminality, and of course tries to be up to date. Thank you for your attention.
Thank you, Ferenc, for your excellent presentation. It was really very good work. I'm still thinking about the incident taxonomies provided, for example, for CSERT teams. And for me, very interesting is always matching what we define as a crime and what, for example, CSERT teams define as incident, how to match this. NISA once made a document that shows what should be the approach to incident taxonomies for also law enforcement to be understandable. So it's really interesting to see those taxonomies for cybercrime. And I think formulating the definition of the cybercrime would be really something important for our research. If there are no questions, I would like invite you to the next speech. The next speech will be provided by Professor Rafał Wielki, who is a Deputy Dean of the Faculty of Law and Administration at the University of Opole. He will present a paper titled New Criminal Phenomena of Cybercrimes Committed on Social Media. So it would be about content-related crimes, mostly. Okay, we can see your screen. Everything is okay.
Thank you very much, Professor. Dear colleagues, dear guests, first of all, I hope that there will be no problems with internet connection, because in my city today we have a quite heavy rain and thunderstorm, as well as I hope that my dog won't interrupt, because she was a little scared and she's staying with me right now. But today I would like to talk something about new criminal phenomena and cybercrimes committed on social media. That's because social media have become everyday life for many people, and platforms. These are platforms for communication and content sharing between private users, companies that are looking for new ways to advertise their services or products. But unfortunately, we can say that social media carries risks that are relatively little mentioned, especially among its users. So, for starters, I think we should have a look at a few facts. Let's have a look at the data connected with social media. We can say that there are nearly 5 billion social media users in the world. That's for June 2023. And it's forecasted that by the year 2027, it will be almost 6 billion users. Right now, Facebook is the biggest social media platform in terms of user base. It has almost 3 billion users. But on the average, the typical social media user interacts with about six and a half social media platforms. They are used by 85 of the world's 3,27 billion mobile phone users. What is also important, an average person uses social media for 2 hours and 35 minutes every day around the globe. It is also said that millennials and Generation Z are the most frequent users of social media platforms. However, we can see the dates here connected with millennials and Generation Z. However, I think that these dates may not be appropriate when we talk about Polish or Hungarian societies because of the years of communism. Also, I think I'm a person born in 1990, and I don't feel that I'm a part of millennial community. So it's quite a thing to discussion. But the fastest growing social media in the social network is Chinese TikTok. And let's have a look at social media platforms and the numbers of users. Well, I told you that Facebook is the biggest one with nearly 3 billion users. The second one is YouTube. But the aim of YouTube is a little different from Facebook. We know that YouTube is a platform connected with videos, so with the comments about videos, likes about videos, and so on. The third biggest platform is WhatsApp. That's a platform for text messaging, communication. So we see that the definition of social media platforms today is quite wide. Um, what is also important, we have an Instagram with 2.5 billion users. This is a social media platform that uses mainly photos, mainly some images, but some of those platforms are not very common in Poland, maybe in Hungary also, as WeChat. WeChat is a Chinese app for sending text messages, something like WhatsApp. We also can say that one of the biggest social media platforms is VKontakte. This is a Russian platform with 1 billion users. Also, we have something different that is maybe not very popular, but as we can see, Twitter, that is very common in Western countries, doesn't have the number of users as Telegram, which was a Russian platform for communicating and text messaging. So we have a lot of social media platforms, and also we have a lot of criminal problems. Why is that? Let's notice that social media is, despite of those great benefits such as connecting people, building relationships, sharing ideas, expanding businesses, and so on, it's a fertile ground for cyber criminals that are searching for unsuspecting victims. And we can say that the prevalence of the usage of social networking websites in today's digital age has also attracted internet fraudsters to set up multiple social media accounts and join many social media platforms as to increase their chance of getting their victims. We should say something about impact on social media and the risk platforms. This is quite pretty important from this criminal point of view. The first thing, we can say that prevalence of social networking websites usage has increased the number of cyber criminals worldwide. The ability to communicate anonymously on social media makes it possible for most cyber criminals to be untraceable after defrauding unsuspecting victims. It's also very easy for cyber criminals to create fake identity on social media and to use it to communicate with anyone around the world. Also, we can say that malicious softwares and websites that look legitimate can easily be shared over social media with as many people as possible within a very short time. We have also a problem with fake news. Fake news, which poses a threat to national or global security, can be easily shared over the social media platforms. With also the usage of social media websites, online fraudsters can create many social media accounts as possible with different identities and use it for criminal purposes. We have also the problem of sensitive information privacy, because most sensitive information that are supposed to be private are now being shared publicly on social media. This of course increases the user's vulnerabilities. We have an availability of social networking websites that makes it easier for cyber criminals to use their multiple social media accounts to send fraudulent and unsolicited messages to unsuspecting victims. There is a problem of proliferation of social networking websites because it has contributed to the increase of cyber terrorism. And finally, the criminal community on the dark web, where criminals buy and sell stolen sensitive information, is getting bigger because the social media platform has become a fertile ground for online scammers. So let's now focus on three examples of criminal phenomena that's connected with social media. We'll try to define them, and I have chosen those because I think these are the biggest threats connected with social media. They can pose a major threat in terms of proliferation of cybercrime. So I would like to discuss the problem of cyberbullying, spreading disinformation, influencing users, and also something new that is called sharenting. Let's start with cyberbullying. Cyberbullying is the use of electronic communication to harass, threaten, or humiliate someone. This can include sending mean texts or emails, posting hurtful messages on social media sites, or sometimes it's spreading rumors online. Cyberbullying is very often associated with cyber stalking. It's a very serious issue on its own, and it has been increasing over the past few years. So we can say that cyberbullying can have devastating effects on those who are targeted and those who witness this happening to someone else. The effects of cyberbullying can be devastating for the victims very much. They may experience various negative emotions such as sadness, anger, frustration, and humiliation. They may also feel isolated and alone, as if they have no one to turn to. The victims may also suffer academically, so it means that as they may be too embarrassed to go to school or participate in classes. It's a very common problem with younger users of social media. There is also an adverse effects on those who witness that it's happening to someone else. Those people may feel scared, helpless, and sad. They may have troubles with sleeping, as research say. Eating may have developed anxiety and depression, and sometimes cyberbullying can be very harmful and can lead even to, in some cases, to suicide. The second problem that we have to define as disinformation spread. We can say that this is the problem very common in social media. Maybe we should ask why people fooled by disinformation are spreading it. Is it just because they believe that this is true? Do they know that the information is fake, but they spread it anyway? How does the way disinformation is presented to influence our likelihood of sharing it? There are many questions that should be asked, but once false material is published online, it can be spread to very wide audiences through the phenomenon of so-called organic reach. While bot networks and coordinated inauthentic activity are important, everyday human behavior may actually account for a great deal of the spread of false information. People who encounter the material may share it to their own networks of contacts, friends, and family, even if they don't deliberately share it, interacting with the material in other ways, such as liking it. This may cause a social network algorithm to increase its visibility, and this is the biggest problem. The people who subsequently see it may then share it to their own social networks, potentially, you can say, leading to exponential rise in its visibility. There is also a high risk of manipulating social media users, and I think that the example of Facebook and Cambridge Analytica showed us, because this company created, excuse me, psychological profiles of the users to create relevant messages that could work on individual person. For example, the company's analysts came up with the idea that someone is afraid of some problem. Well, then such a person was bombarded with messages, fake news, and videos about how this problem threatens him. And this was with a subtle suggestion of who can stop this problem. This is, of course, a matter not only of this criminal life but also of politics. But it's quite important to remember that about this. The last phenomenon I want to talk about is sharenting. This is a new term. This term should be introduced here because it's a word coined from a combination of two English terms: spread, sharing, and parenting. It was probably introduced by Wall Street journal reporters who described parents excessively sharing information about their children's lives on social media. More broadly, it's mentioned that sharing refers to the ways in which parents or parents-to-be use the internet and especially social media with the goal of sharing photos, videos, and other information about their children. And as we begin to deal with the first generation of social media users coming of age, there is a need to study how parents define the boundaries of their digital personhood, how various conflicting interests, and how they justify what is their story to tell. The modern child today is born and raised in a digital world, which is subject to constant monitoring, analysis, manipulation by new technologies, and in turn it raises concerns about childhood is no longer associated with a time of free play and joy. We're beginning to commonly think of it in terms of a period of so-called datafication and surveillance. We can say also dataveillance. Excuse me, I just wanted to. Okay, something is not working with my slideshow, so I will continue. I wanted to say something about the most critical threats of sharing. One of them is identity theft. In broad terms, such an event occurs when a child's personal information is used without its parents' knowledge. While this is becoming widely communicated, many parents are still unaware that social media information is highly vulnerable to being used for fraudulent purposes. Parents who engage in sharing, often including unknowingly, disclose names, ages, dates of birth, home addresses, place of birth, mother's maiden name, school graduations, pet names, sport team names, and so on. And sharing can be a source of critical situation in which the risk of the use of children's information can be used by pedophiles. The data says it increases because, especially since about 50% of parents share information that can lead to disclosure of the location of the children at a specific time. About 4% of parents admit that they shared photos of children who were naked. The social media is very often a stalking ground for pedophiles who are repeatedly downloading photos of children from it and trading them on closed online forums. So it's estimated that many materials collected by pedophiles comes from social networks. So to sum up, we should think something about regulating social media. And we can say that nearly 2 decades after the birth of Facebook and other platforms, the European Union is introducing ambitious legislation designed to clean up the world's biggest online forums. Intended to tackle criminals, protect children, stop consumer fraud, spread disinformation, protect democratic elections, there is coming so-called Digital Services Act. Also, with the Digital Services Act, excuse me.
We cannot see your presentation.
Yes. I am right now fixing it. Okay, I hope it works. What is the Digital Markets Act and Digital Services Act? It aims to create a safer digital space with protection of fundamental rights of people. It's an attempt to establish a new level of playing field for businesses because digital services impact and make our lives easier in many different ways, but we use them to communicate with each other, shop, order food, find information, see some movies, listen to the music. But those evolving services have also made it easier for companies to trade it across borders and access with new markets. So with those benefits I was talking about of the digital transformation, there are also a few problems. A core concern is the trade and exchange of illegal goods, services, and content online. Online services are also being misused by manipulative algorithmic systems to amplify the spread of disinformation and for other harmful purposes. So these challenges and the way platforms address them have significant impact on fundamental rights online. So to sum up and conclude, I think it should be noted that the need to regulate social media is a correct way. Of course, in many cases, one can hear voices saying that this is an attempt to regulate free media, that this may pose a threat to democracy, but I believe it's otherwise. I mean, social media which are not places in any framework become a tool used by criminals and pose a great danger, especially to the youngest users. So the path proposed by European Union seems to be the right one, and as it could lead to a situation where social media service providers begin to comply with European Union law and consumer freedoms rights, which are not currently respected. It's a great way. And I think that this is also the good way to take advantage and control about this criminal situations connected with social media. Thank you very much. I hope that I could show some problems of defining some activities in social media that may be connected with criminal activities. And I think this problem is worth mentioning and researching in the next months during this project. Thank you very much for your attention, and I will be more than happy to answer some questions if you have one.
Thank you, Rafał, for your presentation. I think this topic is very important. I sent you a link to the report made by Stanford Internet Observatory and University of Massachusetts. I think it was this week, so it's very new, according to which Instagram has emerged as the most important platform for buyers and sellers of underground sex content. So yes, social media and its regulation, I think, is important issue. If there are any, if you have any questions, don't hesitate and ask Rafał. You can also use a chat section on our platform. And if there are no questions, I wish to move to the next presentation entitled Special Issues of the Investigation and Administration of Justice in Cybercrime Cases in Hungary, that will be presented by Professor Erika Roth, who is head of the Institute of Criminal Science at the Faculty of Law, University of Miskolc. Professor, the floor is yours. I think I have to change and give you this privilege to have a presenter role. Okay, so I will just change this. Okay, you are the presenter, so you can share your screen.
Okay, thank you very much. I try to share it. No, it isn't. Sorry, it was the wrong. That's okay. Can you see it? Can you see my
Yes, we can see your
presentation?
presentation. You can start your slideshow.
Okay. I hope it will work. So, at the beginning of my presentation, I would like to share quite recent news with you. Probably you heard that prosecutors general of the Visegrad 4 countries had a meeting in Brno on 23rd and 24th of May. And one of the main topics of their discussion was the fight against current challenges of cybercrime. The parties adopted a declaration at the end of the meeting, underlying the determination to support appropriate legal and technical measures in the fight against cybercrime. They also consider it necessary to develop further international judicial cooperation in such matters. This news, among other things, point out that our research is very current. This seminar, I will speak about some issues of investigation, but first I would like to remind you of the fact I mentioned at the first seminar, that being a cyber criminal offers big rewards and few risks, since until recently the likelihood of detection and prosecution of a cyber criminal was estimated to be as low as 0.05% in the US, and this percentage is even lower in many other countries. This very low rate of detection and prosecution of cybercrime cases should be kept in mind when we speak about some aspects of investigation in cybercrime cases. In
Sorry,
my present,
Erika, but we don't see if you change your slide. If you change your slides, we on the platform now it's changed. Now
okay,
it's, we can see
I
it.
prefer that version.
Okay.
So,
okay.
because slideshow sometimes doesn't work,
Okay.
and this is the most safe solution. So,
Okay.
in my presentation, I will focus on three major issues. I will start by general rules of investigation. Then I will move on the specialties of collecting evidence. And finally, I will speak about specialties of coercive measures affecting assets as search and seizure, ordering the preservation of electronic data, and rendering electronic data temporarily inaccessible. Oops. At the beginning, I have to emphasize that the investigation in cybercrime cases is very similar than other cases. In Hungary, there is no special rule concerning law enforcement in cybercrime cases. However, I know that in some states of the US, there are special rules concerning substantive law and procedural law as well. But in Hungary, the situation is different. We have no special rule concerning cybercrime cases. But it is well known that crime in cyberspace operates in a non-traditional way, and the threats and vulnerabilitiness of cyberspace tend to make the use of traditional techniques in police investigation ineffective when applied against cybercrime and cybercriminals. At the beginning, I would like to provide a short introduction to the rules concerning investigation in the Hungarian Code and Criminal Procedure. An investigation consists of two parts, detection and examination. In course of the detection, the criminal offense and the identity of the perpetrator shall be detected to an extent necessary to establish a reasonable suspicion. Reasonable suspicion necessary to involve somebody as suspect in the criminal procedure. And further tasks of detection is to detect evidence, the means of evidence, and secured them. In the course of the examination and after obtaining and examining the relevant means of evidence, if necessary, the prosecution service shall decide on the matter of concluding an investigation against the suspect. If necessary, the preparatory procedure can also be conducted before the investigation. The purpose of a preparatory proceedings shall be to determine whether the suspicion of a criminal offense can be established. In the course of investigation, main tasks of authorities are to define the place of commitment, to identify the person who committed the crime, and to collect and preserve evidence. Next slide. These are the tasks of investigation of other crimes as well, But in cybercrime cases, it could be more difficult and complicated to fulfill them. Where is the place of commitment? Where is the electronic device used for committing the crime located, or where the result occurred? Determining the place where the crime was committed is important for determining the territorial jurisdiction. In Hungary, the Code on Criminal Procedure defines only the territorial jurisdiction of the court of first instance. With a few exceptions, the subject matter and the territorial competence of the prosecution office shall be determined by the subject matter and territorial jurisdiction of the court for which it operates. The competence of investigating authorities is defined by a law other than Code on Criminal Procedure. In the next few minutes, I will speak about the territorial jurisdiction of the court of first instance. Its regulation seems to be a little bit complicated, but we will see that the rules provide, or at least try to provide, solution for every possible scenario. The main rule is that, unless otherwise provided in the Code on Criminal Procedure, that court has territorial jurisdiction for a proceeding where the criminal offense was committed. If a criminal offense was committed within the area of jurisdiction of more than one court, or if the place where the criminal offense was committed cannot be located, the court that took action earlier than the other courts of the same subject matter jurisdiction shall proceed in the case. A court with territorial jurisdiction over the home address or actual place of residence of the defendant or the victim shall also have territorial jurisdiction for a proceeding if the prosecution service submits the indictment to that court. If there is more than one defendant, a court with territorial jurisdiction over one defendant may also proceed against the other defendants, unless such a proceeding exceeds its subject matter jurisdiction, for example, if the second suspect is a soldier. If there is more than one such court, the rules of precedence shall apply. Territorial jurisdiction of investigating authorities is defined by the Minister of Interior decree. Its number is 25 and dated of 2013. And territorial jurisdiction of investigating authorities similar to the territorial jurisdiction of the court of first instance. Due to this degree, the competent investigating authority is that in whose area of jurisdiction of offense, in the case of serial crime, the majority of offenses was committed. If the perpetrator committed the offense in the area of jurisdiction of more than one investigating authorities, or the place of commitment cannot be established, the investigating authority which took action in the case earlier is competent to conduct the investigation. In absence of action, the investigating authority which first became aware of the offense on the basis of its own observation or on a report. These rules means only the tip of the iceberg, because we can find many other rules regarding the territorial jurisdiction of authorities, but here I would like to refer only to the most important regulation. The second question is who committed the crime. Even if the IP address is known, several questions may remain open. Who was the subscriber at the specific time? Did one or more person use the given device? If more than one people had access to the given device, who used it at the time when the offense was committed? We can see that if the IP address is known to the investigating authority, it doesn't mean that they know who the offender was. In most cases, involvement of the service provider is essential. In the criminal proceeding, the court, the prosecution service, and the investigating authority, or in cases of preparatory proceeding, other organizations may request any organization to provide data. Next slide, just a moment. Overt and covert means can be used during the investigation, but application of covert means is only allowed if the necessary information or evidence cannot be acquired by other overt means. I plan to talk about covert means in August because it could be discussed in connection with money laundering. Collection of evidence. In cybercrime cases, certain special knowledge may be necessary to determine what kind of evidence should be collected and which coercive measures should be used, if any. Expert opinion is a very important piece of evidence. It is frequently used in cybercrime cases because members of the investigating authority, the public prosecutor, and the judge do not have special technical knowledge, although they usually, but not necessarily, have user-level knowledge. The Hungarian Code on Criminal Procedure provides a relatively wide possibility of involvement of expert. The law says that if specialized expertise is required to establish or access a fact to be proven, an expert shall be employed. Regarding the involvement of the expert, it should be noted that it is neither appropriate to involve him in the procedure unnecessarily, nor to not involve him in the procedure even when necessary. In the first case, the appointment of the expert may result in unjustified prolongation of the procedure and higher procedural costs, while in the second case, unrecoverable errors may occur. Currently, it can generally be said that in cyber-related cases of crimes, the investigating authority appoints an expert because they are either afraid that the digital evidence will not be recognized, or because they fear that a procedural mistake will be made when implementing the coercive measure, or the prosecutor required the appointment of an expert. The Hungarian Code on Criminal Procedure allows the involvement of a specialist consultant who is not an expert as means of evidence, if his special knowledge is needed to detect, to search for, to obtain, to collect, or to record a means of evidence. It is difficult to separate problems of involving expert and coercive measures because in these cases, even the execution of coercive measures affecting assets as search and seizure may require special knowledge in the field of informatics. In the Code on Criminal Procedure, there is no special rule concerning the seizure of electronic devices. This measure can be a source of many errors, and improper execution can even lead to the destruction of evidence. During the search of IT system, it must be ensured that data accessible through the system remain unchanged during the inspection and recording. Why there is no protocol concerning seizure of electronic devices, the seizure of electronic data is prescribed in details. So the seizure of electronic data may be carried out by copying the electronic data, moving the electronic data, producing a copy of the whole content of the information system or data storage medium containing the electronic data, sizing the information system or data storage medium containing the electronic data, or other means specified by law. I change slide. Okay. An information system or data storage medium containing electronic data may be sized if it may be subject to confiscation or forfeiture of assets. It is significant as a means of physical evidence, or it contains a significant volume of electronic data that needs to be examined for the purpose of taking evidence, or the volume of such data cannot be determined in advance. From the point of view of evidence, the last two option is important. The seizure of electronic data shall be carried out in a manner ensuring, if possible, that the electronic data not necessary for the criminal proceeding are not affected by it, or such data are only affected by the seizure for the shortest period possible. This rule meets the general requirement of ordering and implementing coercive measures. That means that efforts shall be made to ensure that the application of the coercive measures results in restriction of the fundamental rights of the person concerned only to the extent and for the time strictly necessary. Last but not least, I raise briefly the issue of the preservation of electronic data and rendering electronic data temporary inaccessible. Sorry. The preservation of electronic data could be part of the seizure of electronic data. In order to detect or prove a criminal offense, an obligation to preserve electronic data may be ordered. It limits the right of disposal of the electronic data owner, processor, and operator. He is not the offender. The person obliged to preserve electronic data is obliged to keep the electronic data specified in the decision unchanged and provide secure storage for these data separately from other data files if necessary. Other obligations are to prevent the modification, deletion, destruction, transfer, unauthorized copying of electronic data, and unauthorized access to them. After the order to preserve electronic data is issued, the authority that ordered it shall start the examination of electronic data. As the result of such examination, the authority shall decide whether to order the seizure to be enforced in another way or terminates the preservation. The preservation obligation lasts for a maximum of 3 months. Rendering electronic data temporarily inaccessible may be ordered where a proceeding is conducted regarding a criminal offense subject to public prosecution, in connection with which rendering electronic data permanently inaccessible may be ordered, and doing so is necessary to interrupt the criminal offense. It may be ordered in the form of temporarily removing the electronic data concerned, or temporarily preventing access to the electronic data concerned. If I want to draw any conclusion at the end of my presentation, it can be the following. The rules of investigation are not necessarily different in cybercrime cases and other cases. The effectiveness of the investigation and the prosecution probably does not depend on special rules. However, as evidence can be specific and IT knowledge develops and changes very quickly, the involvement of an expert and special regulation for obtaining and preserving evidence are very important. Thank you for your kind attention.
Thank you very much for your excellent presentation. Referring to the problems pointed out by Professor Erika related to determining the subscriber of an IP addresses, I will only say that it is far more effective than following IP addresses to following the money. So we can move smoothly to the problems of following the money laundering. These issues are the subject of the presentation entitled "The Linking Points of Cybercrime and Money Laundering," with particular emphasis of the Hungarian regulation, that will be presented by Professor Judith Jaschko, who is head of the Department of Criminal Law and Criminology and Vice Dean of the Faculty of Law of the University of Miskolc. Professor, the floor is yours.
Thank you very much. Can I present my presentation?
I'm just switching the presenter role. So
and let me introduce my colleagues from the Department of Criminal Law and Criminology, young colleague from our university, and Bence Udvarhelyi he helped me by the prepare of my presentation and have interest on this topic on our seminar. Okay, and I try to share my presentation. Just a moment. Ablak. Itt lesz. Nem. Nem igaz. Mikor a teljes nem igaz. Okay.
We can see the presentation.
Okay, thank you very much. Okay. The title of my presentation is "The Linking Points of Cybercrime and Money Laundering," with a particular emphasis on the Hungarian regulation. Today, I would like to give you an overview of main characteristics of the crime of money laundering in Hungary, with the aim to emphasize not only the traditional but also the virtual methods of the crime. After some introductory comments, I would like to give you the background to the current anti-money laundering regulation in Hungary. Therefore, after a short historical introduction, I would like to analyze the repressive measures against money laundering in the Hungarian Criminal Code. And closing, I would like to tell you some practical issues from the legal practice in Hungary. Nowadays, the penal codes of all EU member states regulate the crime of money laundering. It was codified from the beginning of the ninth years, although the EU regulations only require the prohibition of money laundering. The reason for this was the lack of criminal law competence of the European Union. Only the 6th Anti-Money Laundering Directive imposed the criminalization of obligation. The dynamic change in money laundering methods forces the regulation to be constantly modified. Several studies in the literature point to the danger that current regulation, which was created against the traditional form of money laundering, is not adequate against money laundering using virtual methods. Cyber criminals need money laundering to legalize criminal assets too. Laundering traditional and virtual currencies is one of the wide range of crimes committed by cyber criminals. One of the popular methods is the use of money mule. The money mule is someone who transfers or moves illegally acquired money on behalf of someone else. Money mules can move funds in various ways, not only including through bank accounts, but virtual currency too. It is a well-known money laundering techniques are cyber crimes are often used as a predicate offense for money laundering. It is one of the main questions whether the current legislation is appropriate against these offenders. The second topic is the development of money laundering regulation in Hungary. Similarly to the international requirements, the Hungarian anti-money laundering policy is based on two different pillars. Therefore, we can distinguish between criminal law, repressive measures, which are regulated in the Hungarian Criminal Code, and non-criminal preventive measures, which are specified in the Anti-Money Laundering Act. The domestic regulation of money laundering goes back almost 30 years. However, judicial practice was only able to develop in recent years by the amendment of the Criminal Code with Act from 2020. Hungary has an implementation obligation in connection with the EU provisions in connection to the first anti-money laundering directive from 1991. In Hungary, money laundering has been criminalized since 1994. Parallel with the modification of the Hungarian Criminal Code, it was established a new act about the prevention and combating of money laundering. These anti-money laundering provisions include the preventive measures against money laundering, but in my presentation today, I focus only on criminal law provisions. Since the enactment of money laundering in the Hungarian Criminal Code, the criminal offense has been several times modified. The main reason for the modification was the fulfillment of the obligation of Hungary resulting from EU law and other international obligations. I would like to highlight just one of the amendments. The scope of the predicate offenses of money laundering has significantly expanded since its enactment in the Criminal Code. Initially, money laundering was punishable in connection with criminal offenses punishable by imprisonment or more than 5 years and some other serious crime. According to the modification in 1999, all criminal offenses punishable by imprisonment could become a predicate offense of money laundering. There were only a few offenses which were not punishable by imprisonment. And finally, the new criminal code adopted in 2012 abolished the criterion of imprisonment. Therefore, any punishable criminal offenses could become predicate offenses of money laundering, and so cyber crimes too. The third point is to analyze the Hungarian anti-money laundering regulation in the criminal code. The currently effective Hungarian criminal code into force on 1st July 2013 and regulates money laundering in a separate chapter which contains two criminal offenses. First, the money laundering, and second, failure to comply with the reporting obligation related to money laundering. This is a specific crime in connection with other national criminal codes, I think, but I would like to speak about this crime today. No. The currently effective regulation about the prevention and combating of money laundering and terrorism financing is the Act from 2017. There was another very important amendment of the money laundering. The currently effective regulations entered into force on 1st January 2021 and introduced numerous amendments in order to comply with the provisions of the 6th Anti-Money Laundering Directive. The legislator, using the experience and professional arguments of the prosecutor office, amended the legal provisions with this in mind. Statistics show that the number of the money laundering proceedings in 2021 increased compared to the previous years. And some words about punishable conducts of money laundering, but first of all, some words about the protected legal interest. According to Hungarian legislator, the protected legal interest of money laundering is one, the fight against organized criminality and terrorist financing, and the other hand, the trust in the proper functioning of the legal economy and the protection of the financial institutions and other participants in the financial life. The criminal offense of money laundering in Hungarian criminal code can be divided into 5 main categories of punishable conduct. The first 4 cases can be committed initially, and while the fifth category is negligent money laundering. Okay. And I would like speak some words about the object of this crime. The object of the money laundering is the asset. The last amendment concerning the object of the offense, after which the object of money laundering is much wider than it was before. It's now the assets. One of the reasons for this amendment was the new types and elements of property, various forms of electronic data used for payment, or, for example, cryptocurrencies. This amendment was necessary because this type of object have a characteristic that make them perfectly suitable for moving values in an anonymous way without worrying about any borders. So the predictive offense of the money laundering can be all criminal activity in respect of all forms of money laundering. This provision means the all crime approach. The first type of money laundering is often called dynamic money laundering, since this conduct in most cases results in the transfer of property. The punishable behaviors are conscious or disguises the origin of assets. The second form of money laundering regulates several perpetrating behaviors, typical behaviors in everyday life and in the financial area. It is a dynamic form of the money laundering crimes too. It must be underlined that the crime can be committed intentionally and with the intent to conceal or disguises the origin of the assets. Okay, and some words, I have not so much time, so I would like to speak about these slides. There are 2 other types of money laundering, and in the practice is very important amendment was the 4th type of money laundering. Former, it was a separate crime in the criminal code, dealing in stolen goods. And about the punishment of money laundering. the intentional money laundering is punishable with imprisonment for up to 5 years. Aggravating circumstances, if it is in the case, it is the imprisonment between 2 to 8 years or between 5 to 10 years. And negligent money laundering, this is a misdemeanor in our criminal code, punishable by imprisonment not exceeding 2 years. In case of aggravating circumstances, 3 years. And it is important to underline in Hungarian criminal code, the preparation for money laundering is punishable too, with imprisonment not exceeding 1 year. Okay, and the next slides is about the new type of money laundering, the negligent money laundering. The Hungarian legislature punishes as well this form of crime. And it is very important to emphasize that the punishable conduct can be committed intentionally in this case as well. It is the perpetrator who is negligently unaware of true origin of the assets. And some practical issues from legal practice in Hungary. In the prosecutorial practice, money laundering was committed or is committed with the use of cryptocurrencies in several cases. Based on information of the Prosecutor Office of Hungary, the typical predicate offense of money laundering using cryptocurrencies is fraud or drug trafficking offenses. And some statistic dates about the number of certain registered money laundering crimes in the last years. You can see, or we can see, that the recorded registered crimes, the number of acts shows an increasing trend. And it can be emphasized too that the number of reports related to virtual currencies also appeared in the practice of the Hungarian financial intelligence units, FIU. According to the report of Hungarian FIU, 38 virtual currency cases were reported in the year 2017. And about my conclusion, it is difficult to detect suspicion cases in the virtual space. This is especially true for the money laundering cases. The main problem is the anonymity that cyber crimes and especially cyber currencies offer. The area was initially completely unregulated. There were changes in this area in the EU and in the member states in the recent years. The object of the offense of money laundering must be sufficiently broad. It was the main reason for the last amendment in the Hungarian criminal code. And I would like to underline very important is in the fight against money laundering, the preventive measures. But about this topic, I would like to speak another seminar. Thank you very much for your attention.
Thank you very much for your presentation. Are there any questions to Professor Judith? If there are no questions, so last but not least, I'd like to ask Professor Piotr Burczaniuk, representing the Department of Theory and Philosophy of Law of the Faculty of Law and Administration, Cardinal Stefan Wyszyński University in Warsaw, for the presentation titled Types and Scope of Operational and Reconnaissance Activities of Law Enforcement Agencies for Countering Cybercrime, Current Status and Challenges. So, Piotr, the floor is yours.
Thank you.
We can see your presentation, so
yeah.
You are prepared.
Thank you very much. You can see my presentation. I suppose you can also hear me. The topic of my speech today will be an attempt to present the current state and legislative challenges in the area of operational and reconnaissance activities of Polish law enforcement agency in the aspect of combating cyber crime. The beginning of this consideration must be preceded by a reflection of the definitional scope of the term operational and reconnaissance activities. This is because in the Polish legal system, it is used in the competence acts of the services to denote one of the types of activities to which they are entitled. Analysis of these laws leads to the conclusion that as many as 11 services are currently authorized to implement them in Poland. These are in turn the police, military police, border guard, state protection service, national fiscal administration, prison service, internal security agency, intelligence agency, military counterintelligence service, military intelligence service, and the Central Anti-Corruption Bureau. Thus, the power to provide operational and reconnaissance activities is currently held by, in Poland, 6 services of a police nature, in which case they are accompanied by investigative and administrative order power, and 5 services regarded as special services, in which case they are accompanied by analytical and informative powers. The indicated division of activities reflects the scope of jurisdiction granted to these services. In the case of police services, focus on preventing crimes and prosecuting their perpetrators. In the case of special services, aim at obtaining and transmitting informations. Importantly, in the Polish legal system, there is no statutory definition of the term operational and reconnaissance activities. Its introduction without success has been repeatedly postulated. Therefore, when defining it, it is necessary to refer to the achievements of legal doctrine. It indicates that operational and reconnaissance activities are activities of authorized state bodies which consist in secret and non-procedural actions of authorized services in order to fulfill their task aimed at preventing crime and other negative social phenomena. These activities are mainly provided outside the criminal process, although they often serve the purpose of fulfilling the task of already conducted or future criminal proceeding. It should also be emphasized that there is no closed catalog of operational and reconnaissance activities in Poland. Importantly, only the most complex types of them, the most strongly interfering in the sphere of constitutional right and freedom, receive statutory regulation. These include, first, operational control, second, so-called control purchase, third, so-called classified consignment, fourth, collection and processing of telecommunications, postal, and internet data, fifth, the so-called camouflage that supports them. Other types of operational and reconnaissance activities are governed by the classified internal regulation of the individual services, which defines the ways, methods, and forms in which they are carried out. In view of this above, only activities that are openly regulated in the statutory level will be subject to further analysis. In the context of the above, turning to the main thread of the present considerations concerning operational and reconnaissance activities used to combat cybercrimes, it must be clearly indicated that their designation must be done by referring to two issues. Firstly, the identification of the Polish services within those jurisdiction the fight against cybercrime remains. Secondly, a presentation of the specific operational and reconnaissance power wasted in these services, the use of which remains in relation to the fight against cybercrime. In the first aspect, an analysis of the competence of Polish law enforcement authorities leads to the conclusion that the key authorities responsible for combating cybercrime in Poland remain the police and the internal security agency called next ABW, and to a narrower extent the military counterintelligence service. Of the above-mentioned services, however, it is the activities of the police that remain paramount in combating cybercrime. This is due to both the characteristic of this service and its organizational preparation. This is because since 2022, there has been in place in the police the Central Bureau of Combating Cybercrime, which is a unit responsible for carrying out in the area of the whole country tasks in the field of identification and combating the prevention of crimes committed with the use of an IT system, ICT system, or an ICT network. This unit is authorized to carry out all the above-mentioned operational and reconnaissance activities. Turning to a discussion of the first of these activities, operational control, it should be emphasized that its legislative shape is a consequence of, common to all services, the implementation in 2016 of the Constitutional Court judgment of July 30, 2014. Pursuant to this regulation, the formal ordering of operational control is made by a decision of a competent district court upon a written request of the competent police chief, submitted after obtaining the written consent of the public prosecutor general. In the case of the police, operational control may be ordered in order to prevent, detect, establish perpetrators, as well as obtain and record evidence prosecuted by police indictment of intentional offenses involving inter alia relevant from the perspective of the subject of the present deliberation. First, offenses against sexual freedom and morality, including the promotion of pedophilia. Second, offenses against the activities of state and local government institutions, including false alarms. Third, Information protection offenses, including computer hacking and computer eavesdropping, and accessing and damaging computer data, computer system disruption, and the manufacture of hacking tools. 4. Crimes against property, including phishing. 5. Offenses against economic turnover, including money laundering. In the case of the ABW, the Secret Service, on the other hand, the scope of application of operational control includes the offense of unlawful disclosure or use of classified information, espionage, terrorism, and a catalogue of offenses against property and against economic turnover, with the express provision that they must harm the economic basis of the state. The Police Act and the ABW Act specify the manner in which operational control is carried out, emphasizing that it is carried out in secret and consists of: first, obtaining and recording the content of conversations conducted by technical means, including through telecommunications networks. Second, obtaining and recording images or sounds of persons from premises, means of transport, or places other than public places. Third, obtaining and recording the content of correspondence, including correspondence conducted by electronic means. Fourth, obtaining and recording data contained on computer storage media, telecommunications, terminal equipment, information and communication technology system, and the fifth, gaining access to and controlling the content of shipments. The indicated provisions do not specify the technical aspect of the application of operational control. This seems to be a conscious will of the legislator, leaving this issue to the services in order to ensure their flexibility of operational in the condition of technological variability. Therefore, in the Polish legal system, it is not required to directly grant the services the right to use, for example, software called state trojans to break through the security of telephones and computers and to read the contents of devices used by persons. Such regulations exist, for example, in Germany. The scope of activities falling under operational control, in particular including so-called electronic surveillance, undoubtedly remains the most important and effective tool in the hands of law enforcement agency aimed to combating cybercrime. Indeed, the detection and prosecution of many types of cybercrime is only possible thanks to the ability of authorized services to monitor electronic means of communications, content delivered electronically, or finally electronic data itself. It should be added, however, that the effective application of this activity, mainly due to technological developments, faces numerous difficulties. Among the most frequently mentions in the literature are, firstly, the issue of cooperation with foreign, non-resident providers of electronic communications. Secondly, the methods are assessing the content of the message, which is currently encrypted in the case of most communicators. Thirdly, access to data increasingly processed in the so-called cloud, physically located in the different parts of the world and also encrypted. Fourthly and finally, the anonymity of the activities of network users, mainly in the area of the so-called darknet. Different operational and reconnaissance activity from operational control remains the so-called control purchase. Pursuant to the Act on the Police and the Act on the ABW, the relevant police chief or the head of the ABW, after obtaining the written consent of the relevant public prosecutor, may order for a specified period of time activities consisting in, inter alia, the secret acquisition, disposal or takeover of objects originating from crime. This activity is called control purchase or police provocation. Although this activity was originally intended to infiltrate a criminal group trading in illegal goods, there are currently no obstacles to using it to combat cybercrime. This could be done through, for example, the control purchase of stolen confidential data or hacking tools, or even cyber attack services. Another statutory operational and reconnaissance activity remains the so-called secretly supervised consignment. According to the Police Act, the competent police chief may order, secretly supervise the protection, movement, storage, and circulation of objects of crime, if this does not create a threat to human life or health. This action in practice consists of deliberately failing to intervene or refraining from immediately arresting the suspect in order to allow further collection of information on criminal activities and identification of other persons connected with the crime. When carried out effectively, this activity makes it possible to identify entire criminal networks and apprehend key individuals responsible for the crime. Traditionally, this activity has been used to combat mainly organized crime, e.g. in the area of drug trafficking. Its use to combat cybercrime is a complex and it seems practically limited issue. This is due to the specific nature of criminal activities in the online environment. For in most cases, cyber criminals using technological safeguards such as VPNs operate anonymously, effectively concealing their identities. In addition, some form of cybercrime, such as hacking attacks, among others, can be difficult to monitor in real time. In addition, both the police and the ABW are authorized to obtain and process three important types of data. Firstly, telecommunications data, including so-called billing and other telecommunications data. Secondly, postal data, including data on the postal operator, the postal services provided, and information identifying the users of these services. Thirdly, online data processed by providers of electronic services. This activity, along with operational control, is a key tool used to combat cybercrime. Moreover, due to the simplified, in comparison to operational control, mode of obtaining this data, it makes it an essential tool. It works mainly in identifying suspicious activity. It makes it possible to link the digital traces aggregated therein, leading to the identification of the perpetrators of cybercrimes. In addition, a broader analysis of this data and identifying patterns and anomalies in the use of telecommunication services can create a suspicion of particular types of cybercrime, particularly computer fraud or sexual offenses. An important political and legal debate is currently taking place around this activity, and more specifically around the scope of telecommunication data collected by operators at both European Union and national level. On the one hand, the Court of Justice of the European Union, in a number of rulings, has questioned the universal, generalized, and the Federation obligation to retain all traffic and location data of all subscribers and registered users of all means of electronic communications. On the other hand, the national legislator in Poland draws attention to the current lack of coverage of electronic communication undertakings, e.g. providers of email and instant messaging services, by retention obligation. His proposal this year changes in this area, covered by the draft law on electronic communications, have met with a negative opinion from both public administration bodies, publicists, and representative of social organization. It should be added that an important support for the described operational and reconnaissance activities is the institution of the so-called camouflage, preventing the concealment of data identified the officers and the means he/she uses to perform official tasks. In conclusion, this reflection, I would like to emphasize that due to the limited time of the presentation, I have presented them in a highly generalized way. Wider consideration will be included in the content of the chapter being prepared for publication, summarizing the ongoing research of our group. However, I would be happy to answer any question you may have.
Thank you very much, Piotr. Are there any questions to our presenter? I don't see. So, thank you very much for participating in this seminar. the subject of which was the extremely important but also extremely difficult problem of the definition and scope of cybercrime. In place of the summary, I'd like to add one more issue to think about. In Polish legal literature, a procedural approach to cybercrime has been proposed in addition to the substantive approach. In the procedural approach, computer crimes include all acts prohibited by criminal law, the prosecution of which requires of law enforcement and justice authorities to gain access to information processed in computer or ICT systems. So our research is therefore extremely relevant due to the fact that in this approach, cybercrime is any crime. Because electronic evidence is collected, I think, in every proceedings we have now. So also in those involving murder, rape, or tax fraud. So preserving evidence in such cases also requires international cooperation. So I warmly invite you to the next seminar, which will be held on 4th of July and will focus on international cooperation in cybercrime cases. Thanking you for your attention. I wish all the speakers further fruitful research and all of you an enjoyable afternoon. So thank you very much for the attention.